Welcome back to the Law Unscripted, where we discuss all the things you never knew,
never understood,
and no one ever told you about the law. We are welcome back, everybody. Truly welcome back. We are finally in season 2. We did not do a summer season because our host Chelsey Rogers
took the bar, guys.
Taking the bar. Which state did you take?
Maryland in July of 2023. And we're going to cross our fingers that in about a month I should have results, which is also making me nauseous, to be perfectly honest.
Fair enough. I totally get that. So Chelsey, as she stated, she's our resident law student who has now taken the bar. We're waiting on the results. But she and I have been working together for a number of years. I'm Virginia Tehrani. I'm with Tehrani Law, LLC, because you never need a lawyer.
Till you do.
There we go. And we are truly back. So the first season we took through the winter and spring at the first of the year for 2023. We've skipped the summer and now we're at the fall of 2023. And what we're going to try to do this season is continue to take those little snatches of small issues that are part of bigger ones, but to break down the smaller ones. And usually we're on the couches behind me. But we've also had a whole bunch of things happen in our lives. So today we're going to do it a little bit differently and see how it goes.
Hopefully we will be back on the couches in no time.
Yes, hopefully so. My one little doggy's on the couch. You can't see him. But Charlie's joining us at least because he always hears Chelsey's voice and comes running. Isn't it sweet?
Oh, I love him so much.
You who are joining us again, we do still have dogs. They're just kind of in the background and we're going to keep working our way back to those couches. But today we're going to talk about Terry stops.
Oh my gosh.
All right. Every law student is going to know, oh my God, I know a Terry stop and have a lot of opinions about them. But for those of you who haven't heard them referred that way, it's a stop and frisk.
That's what I was going to say. I feel like everybody knows, even if they don't realize it, what a Terry stop is. I feel like it's on every show. You know, put your hands up against the wall and you see the frisk. You know exactly what it is.
Right. Do you have a gun? Is this your gun? And they're pulling it off of holsters, out of holsters, pockets, and wherever they can find guns.
Yes. Whatever your favorite, law show is, you've seen it. I obviously have lots of strong opinions about it. Because this is relatively new.
With it.
Okay, right. Because we're starting with it, but this is relatively new. So what we're talking about is the Fourth Amendment. That's your, search and seizure. That's where we're starting. But this was like an interpretation of that didn't happen until almost the 70s. It was 1968, Terry v. Ohio, right?
Yes, that's absolutely right. So Terry v. Ohio, that's why it's called a Terry stop. Kind of like the Miranda warnings is. They're called Miranda warnings because that was the case. The defendant was Miranda. So in this case, Terry is the defendant and it's a Terry stop based on him. But I think we need some context with the Fourth Amendment because you were right. This is all based on the privileges and freedoms and protections of the Fourth Amendment, which talks about search and seizure.
Good old Constitution.
Yes, go back to the very basics.
Pull out your pocket constitutions, everyone, and we'll keep going.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized.
Yes.
That's the basics. But for Terry stops, there's no warrant.
There's no warrant. There's no probable cause either.
Which seems weird because the constitutional amendment says probable cause and warrant. But this is not either. It's not a warrant and there's no probable cause.
Our returning listeners now understand why I have such strong opinions about this. They're starting to see the pieces come together. But right. So essentially, the Fourth Amendment says you need a warrant or you need probable cause. You have to see someone do something. You have to do that. And then if not, You can't seize them. You can't stop them, right?
It's unreasonable. That's what it says in the Fourth Amendment.
Yes.
It's unreasonable if it's not through a warrant based on probable cause.
Right. And so an arrest is a seizure. You're like being seized. So that's what it's talking about. You can be detained as a seizure. But apparently, according to the court in 1968, being stopped and frisked is not a search and seizure, which I think is a wild thing to declare.
It does seem so. Because like you're saying, if you stop someone, that is technically a seizure. It feels fundamentally like a seizure. If you're telling
not
someone
free to walk away,
stand here while I frisk you, you're preventing them from leaving. You're seizing their person, even for a specific, even if it's a small amount of time, it's still an appreciable amount of time. So how is this different than the requirement for a warrant?
Here's the thing. I don't see, I obviously don't agree with the court here, but they essentially make the argument that it's not the same as an imposition, like as much of a restriction on the freedom as you were saying. I just have a hard time believing that. I just don't know if I believe that, because what they say is that the officer needs to have not probable cause, but some reasonable, articulable suspicion.
Exactly.
Which is not the same as probable cause, but is more than just something. They don't like to give bright line examples of this, but they're like, it's not probable cause, but it's something. Good luck, guys.
I mean, it seems to put, so you have nothing, you have no facts for any crime. Right. Clearly nothing can happen. But then there's probable cause, which is put in here by an amendment to the United States Constitution back in the very beginning of our
standard.
And now we've got, we'll put reasonable suspicion in between. Right. We'll have nothing, and then we'll have probable cause, and then we'll have reasonable suspicion, which isn't in the Constitution. Those words do not exist.
No. And so this reasonable suspicion has to be, as I've said, just something. And the whole idea with the frisk is that that part is for officer safety, right? They're not being searched like they would if there was probable cause to search a person. If you're arrested, they can search your person. What the court is saying is that this is just about officer safety. If they stop you, which they now can do, if they have some reasonable, articulable suspicion to stop you, they have the right to then frisk you for officer safety, to make sure they're, that's the pat down. However, since then, right, you're like, okay, great. They're supposed to be frisking for weapons, but they often find other things that gives them probable cause. So this is what's happening. Yeah. My argument here is that these are just reasons. This is the court saying, let us give you some justification for your pretextual stops. But hey.
Yeah, I mean, it does seem like that. So if you have reasonable suspicion of what, I mean, most
of what? That's what I'm saying. Like, what is the suspicion? Was I looking around? Was I walking too fast or too slow? Because this is what happens, is that those things then, both of them, to be clear, walking too fast somewhere and walking too slow somewhere, have both been used in cases and upheld as reasonable suspicion. And I'm like, then what am I supposed to do? What am I supposed to do?
I can't do anything. I'll be stopped and frisked. I can't help it. What do I do? I'm standing still.
That's what I'm saying. I actually wrote this in an essay, and I'm laughing thinking about it now. I said that Terry v. Ohio was the death of the Fourth Amendment. A little dramatic, but I really felt that way.
I mean, I got it. And I think, to me, the base of the rule is to give the officers the ability to protect themselves. Yes. I think, to me, the fundamental idea is officer safety. Yes. Because through this rule and the way that it's been reviewed subsequently and upheld is for officer safety of, if there's a knife, if there's a gun, then we want to make sure that the officer can detain this person long enough to determine, am I at risk? Right. Is my health, my life, or these up for grabs? Because I mean, I gotta admit, as a police officer, I'm not a police officer, but my husband was, and I've worked with a lot of them. I would like this rule. a lot. I would be, fanfaring, doing a parade for this rule of, I can stop someone if they have a weapon, because this is not a full body search. This is not a cavity search. This is even I'm going to put you in handcuffs. This is, let me hold you there I'm
going to ask you some questions. And before I do that, let me just check I'm safe.
Yeah, because the rules that have interpreted it say it's outer clothing. You have to pat down. You can't grope. You can't feel. You can't manipulate anything. Right. So if you feel something in their pocket, but it doesn't feel like a weapon, you can't go searching their pockets.
Right.
But if you feel it and you think that it's drugs, you might have now probable cause to
that. Okay. This is why I get frustrated about it. It's about the drugs. I understand officer safety and I'm not disagreeing, but I think more often than not, it is used to get probable cause when they think someone has drugs. And they say, oh, well, it's reasonable to assume that someone who is selling drugs is also carrying a weapon. So I'm going to pat them down for a weapon for officer safety. And what they're actually going to do is pat them down and be like, well, I felt the paraphernalia or whatever it is.
Right. And I think that's true. It's, we've got to have, they can feel evidence of other crimes, but you really have to have some kind of independent justification that brings that portion up to probable cause. So in my mind, yes, they have reasonable suspicion still, and we're still acting under that there's probably, there's reasonably, it seems that you have drugs in your pocket, but that hasn't risen to the level of probable cause.
Absolutely.
Unless you then see, there are the scales and the baggies sitting in your back seat. That's the other marijuana that you have on your table. Now I have probable cause, but it does kind of, in both our minds, it seems to truly put a whole nother evidentiary rule in there.
Right. It's unclear, I think, is the thing that's frustrating to me, at least, because we've had probable cause since the amendment, the Fourth Amendment, and that have, I would say, a pretty significant portion of case law interpreting it. I think everyone has a good idea of, judges across the country have a good idea of what is probable cause, what is not. And then you just add this in, like, that's 1968 was not that long ago. And so then it really is not. And so this is when it's happening at the Supreme Court. And they're going to go, okay, now they have given us this new standard of reasonable articulable suspicion. What does that mean? What does that mean? And then the kind of lower courts are left to figure that out.
Yeah. And they, they've done their best, but this is why we continue to get these types of cases on suppression of evidence motion, on appeals. Was this a Terry stop? Did it rise to a higher level of an arrest?
Or were they being detained or not?
Yeah, because it's all a question of custodial interrogation.
Yes.
Or in custody. Was this person in custody or arrested? These are comparable terms. And if it didn't rise to the level of arrest, do we have justification for a stop? And it's just minutia that we're looking at, different facts, but each case is different. So for Terry, it interprets the stop based on the totality of the circumstances. Yes. It's this crazy objective test, as if any of this is objective versus subjective.
This used to actually, fun tangent, the whole idea of an objective test versus a subjective test was really hard for me to understand in criminal law, like my first year, because I was like, you're using the word objective, but what I'm hearing is a lot of things that to me are very subjective. And so I had a really hard time with that in my first year criminal law class because I was not clicking, like I was not getting it.
It does seem to be used interchangeably. So in essence, a subjective test is one where it's your own thoughts.
Right.
I believed, if I were the officer, I really believed that this person had a gun. So I patted him down to protect myself. Versus the objective test is kind of this made up test that says a reasonable person in this same situation would have believed there might be a weapon. Right. Well, I'm going to tell you, I believe there might be a weapon. I think I was a reasonable person.
Right.
I'm reasonable, then it meets both the subjective and the objective
test. Right. Because you're going to get the officer who's like, I've been an officer for 10 years patrolling this high crime area. It's reasonable to believe that this person who I saw what looked like some exchange, it's a reason. Right. Then you're like, okay, well, who am I to say that the officer is not reasonable?
Exactly. And in essence, it's a reasonable officer. It's not even a reasonable person. It's a question of would a reasonable officer in the same situation
interpret it the same way.
Interpret it the same way. And you're hoping that 9 out of 10 at least times they would do the same thing or think the same thing. But it is this test of reasonable person, reasonable articulable facts. You can't just say, well, I felt like it. I had a hunch.
I was on the same brainwave, right?
It seemed suspicious.
Yes. But then but some of the reasons they use, I'm like thinking of a very particular case that I saw at the public defender's office. This was you want to hear, they actually use this for probable cause and not reasonable suspicion. And this was the wildest thing I heard said. He said, the young man bent down to tie his shoe and did not actually tie it. And they said they had probable cause and that was their reason for probable cause. But I don't even know if that is an articulable suspicion, in my opinion.
I agree. Is that even a reasonable, articulable suspicion, reasonable suspicion? I don't know. It doesn't even seem that high.
He testified to that. And when I tell you, I'm obviously just sitting there as an intern, my jaw dropped because I was like, even the judge kind of like cocked his head. It was a rookie officer. And even the judge kind of looked over and was like, what did you say?
Yeah. No, that's a hard one. And we're all looking at it. This objective test. Agree with you. We're all looking at it in our own mind's eye.
Yes.
Is if we interpret it that we're reasonable persons, people, that we believe we would have thought that thing, done that thing, then of course it's reasonable. So how many other judges and people do you have to get to agree with you that that was a reasonable act to see this is objectively reasonable? So I think you were actually onto something there with your argument that this all seems subjective.
It was very confusing for me because I didn't feel like, in my mind, an objective is a checkbox, right? You can say this thing happened, this thing happened, this thing happened. You can distribute a list of those things and everyone's going to get to the same conclusion. So I had a very hard time. I know that sounds like I'm an idiot, but truly my first year of law school, I had such a hard time understanding what people were telling me with objective versus subjective. I just ended up ignoring those words altogether and just memorizing what the standard was. And because I was like, I don't understand how these words are being used.
Well, that makes sense. And I think it's reasonable.
Well, thank you. See, look at that. A reasonable law student would agree.
A reasonable law student. I like it. That's the next test that the Supreme Court's going to come up with.
Oh my gosh.
But in the meantime, yeah, this is so crazy. So this is truly it's law.
It is.
Technically, it's an interpretation of the Fourth Amendment. It is not something that's new, allegedly.
See.
But the question is, I think ultimately, did the court create new law through Terry versus Ohio, or did it interpret the old one? I mean, you could really make a good argument either way. This is the same, God forbid I mentioned these phrases, but this is the same with birth control and abortion. They're not. So did the court interpret the Equal Protection Clause, or did it create a new rule that wasn't there to begin with?
I might surprise some of our listeners here, but I actually absolutely agree with that. I think I 1000% do. I think when we started reading in privacy rights to the Constitution, it doesn't make sense to me. I feel like I'm a very black and white person in a lot of ways. Those words aren't there. So what do you mean that you're reading it and finding that? And that's essentially what's happened. We said that there's all these fundamental rights that aren't enumerated, but they are in the essence of the Constitution is basically what happened. And so starting with Griswold v. Connecticut, we just started reading things in. And so, I guess people would be surprised, but that to me was very frustrating. I mean, at this point, I think we can't go back. there's just too much law that has happened since then. So I don't think the solution to any of this is try to undo it. I don't think we can. But I think if I could teleport back then, I would want to stop it. Okay.
No, that we can't take it back because Griswold, the case that you just referenced, is the birth control case.
Yes.
And then we've got Roe versus Wade. And within the last 2 years that you and I, this is 2023.
Yes.
Wade has been overturned.
Right.
And I thought you could take that back. So if that could be taken back, what about Terry?
Hey, look, I'm not opposed to that because this is the thing. I think the principle for me is very frustrating, even though obviously it's no shock on here that I was very devastated when Roe v. Wade was overturned. But I don't like this idea that we're like creating law by some people are reading this imaginary language in places. And that's how I feel about Terry too, is that where does it say that? Where are we getting that from? If we want that to be the standard, tell your congressperson to draft a bill.
That goes back to strict construction.
Yes, which makes a lot of sense. My black and white thinking is like, there's a process for this to happen, and a judge saying so is not that process.
Yeah, because are they legislating from the bench? That's the question.
Yes.
Technically, according to our forget the Bill of Rights, these amendments, go back to the Constitution itself before
separation of powers. It's like this whole fundamental thing of we want a checks and balances. And then, which again, I think it's funny because obviously this would impact things that I am in favor of. But at the end of the day is that I like things to follow the rules.
Right. And this is how it is. It's like, Article 1, 2, and 3, executive branch, legislative, and judicial. Which one are we going to pick? Well, technically, like you're saying, the legislative branch, Congress,
could make this a standard.
Make a new law. So if we're supposed to have reasonable suspicion, well, shouldn't they put it in? Because I don't read that in the amendment.
Right.
Whereas the judicial branch is supposed to be interpreting.
So if you have, like, in my mind, exactly say Congress did this, we throw out Terry and Congress makes a law saying essentially what the holding of Terry was, then the only thing the court is deciding is, did the certain facts in this case meet reasonable articulable suspicion? That is the job of the courts, to interpret the facts to the law as it is written. And I don't know where this got mixed up,
but these words weren't in there.
My innate frustration with a lot of things. Like, I think con law is so fascinating. We are starting to walk things back. I don't know how that'll go, but in my mind, I'm like, I'm in favor of privacy rights and birth control and abortion and all of these things. But at the end of the day, it doesn't say it in there. Okay. It just doesn't.
It doesn't.
Why are we playing this game of saying there are this but I mean, it's also interesting because the word like freedom isn't in the Constitution. I mean, there's a lot of things, but it's like, we can just make new laws. We don't have to read things in to the Constitution. I don't know why that became the way we did things.
Would that it were so easy? I think, in my own political type opinion, the legislature is essentially ineffective now because we have our party system is so
polarizing
that we can't have agreements on anything in the legislature. So we leave it up to our judges to make rules for us because we can't convince 100 people in the Senate or, however we can't convince them to make a new bill because they won't agree on it. They won't agree what the privacy rights are. They won't agree to reasonable suspicion or not reasonable suspicion, which is why I think that, being also more of a strict constructionist view of what not in there, why that's where we're headed. But in any case, that's a Terry stop. For those of you who sort of know about it and sort of don't, or who are looking for a better explanation, we do have them. You are allowed to be stopped on the street to make sure that you don't have a weapon, but there has to have been some kind of fact that led the police to believe that you were a risk to them and their safety. And that they could pat you down without manipulating anything, without moving you anywhere. They can't take you down to the station. That is not a stop and frisk.
No.
A limited, you are where you are. You don't move from where you are. You're patted down, weapon or no weapon, and then it's done. Unless they find a weapon and you were a felon. Anyway.
There's a lot that could happen from there.
Yeah, there's a lot that could happen from there.
Maybe
but
if you are a felon, you just keep walking. You don't hear him and you just keep, but not too fast.
Not too fast and not too slow.
Continue walking at a moderate pace.
Or just stand. It's, whatever.
Freeze, lock on.
Which is
am I being detained? And am I being detained?
Am I free to go? Always ask.
Yes.
That's my advice. I don't give advice. I am an attorney. We don't give advice on here, but with the general advice I can give and feel comfortable doing is if you feel that you are being detained by the police, always ask them, you can do this no matter what. Am I free to go?
Yes.
Am I being detained? Am I free to go? I think by asking these questions, you're better off in the long run.
Yes. And don't answer questions without an attorney. You can be helpful and answer questions, but have an attorney there with you. It's never a bad idea.
Yeah. Let me make a phone call.
Yeah. I'd be happy to help. Give me just a moment.
Just one moment. Who are you calling? My attorney. Just give me a second.
Just a little second.
While you're going through Terry stop. So that's where we are today. I think we've kicked off the new season with a great topic. We will be coming up with more of the little bitty topics within the larger subjects as we go through to help you understand all the things about the law and the legal system that you didn't know.
Didn't understand.
And no one ever told you. So in this case, like and share.
Yes.
Subscribe to our channel, put some comments in there about what you think about the Terry v. Ohio decision, about the stop and frisk rules. We may not always comment back, but feel free to comment what you...
Hey, and drop a topic if you liked this one or it made you have questions about other traffic stops or anything else. And you might inspire us for our next couple of topics.
Write it in there, share with everybody, and we will see you on episode 2 of season 2 next week.
Woo-woo.
Yay. Thanks, Chelsey.
Bye.
Yeah. Bye, everybody. See you next time on the Law Unscripted.